Legal research is not limited to reading cases and statutes. The body of government-created law is not the entire scope of legal authorities. The other key component of legal research is using secondary authorities, texts that explain the law and guide the research process. Legal research can be a confusing process. The rules that govern any given issue are spread across many statutes, cases, and regulations. A given law might have some rules that you need to know, and some that are irrelevant. You don't know in advance where the relevant rules are, and that's to say nothing about how obscure the language can often be. But much of the work of researching a legal topic has already been done for you, as legal scholars have taken those rules and sorted them into the relevant topics so they can be found easily. Secondary sources are how you can use that work to your advantage. Secondary authorities explain how the law works, teach you what terms you can use when searching through cases and statutes, and contain citations to the relevant laws. Most of the time that you have access to a good secondary source on the topic you're researching, you will want to consult it at some point. Unless you have a very strong baseline understanding of the issue and know what terminology would be used in the cases and statutes, you will likely want to begin the research process by consulting a secondary source. Even later in the research process, you are likely to encounter an unanticipated legal issue, and when that occurs, you may need to return to the secondary sources. This video will not attempt to introduce you to every type of secondary source. Instead, we will cover some of the most important sources that can be used in many different applications. If you're looking for a general introduction to how an area of the law works, a legal encyclopedia is a good entry point. Legal encyclopedias aim to cover the entire span of legal issues, with entries that give an overview of how a given area of law functions. Because they must cover such a broad range of topics, encyclopedias do not cover the issues in much depth, so you may not find an answer to a narrow question. However, you will find citations to other authorities, both primary and secondary, that will help you with more specific issues. There are two general types of legal encyclopedias: national and state-specific. National encyclopedias attempt to summarize the law as it generally works across most jurisdictions. This means that you cannot assume that the law in the jurisdiction that you're practicing in will follow the rules stated by a national encyclopedia. Moreover, you may not see a citation to a primary authority that's within your jurisdiction. That said, you can still learn about what terminology to use when crafting searches when reading a national encyclopedia entry, which will help you find the controlling primary authorities in your state. The two national legal encyclopedias are American Jurisprudence, or AmJur, and Corpus Juris Secundum, or CJS. AmJur is available on both Westlaw and Lexis, while CJS is only on Westlaw. The library has American Jurisprudence in print if you do not have access to those databases. Many states also have encyclopedias that focus specifically on the law in that jurisdiction. The benefit to this is that any rule statements you find will be applicable to that state, and all citations will be to in-jurisdiction laws. In Illinois, we have Illinois Law and Practice in Westlaw, and Illinois Jurisprudence in Lexis. The next type of secondary source will be familiar to any law student: the restatement of the law. The restatements are an attempt to synthesize the rules in areas of law that are traditionally governed by common law, that is, laws created by courts and not legislatures. The hope is that courts across each jurisdiction will adopt those rules, creating uniformity across the country's various legal systems. Restatements have the benefit of making common law rules much easier to navigate because they are arranged topically, like with a statutory code. Of course, different courts may or may not actually implement those rules. Restatements will cite to cases across various jurisdictions that cite to a restatement rule, therefore leading you to the primary authority that you can cite in your argument. Treatise is a broad term that means a book that focuses on a single subject. Treatises can vary in how in-depth they get. Some, like the Nutshell series, are intended just to serve as introductions. Others, however, can go into great depth. The most in-depth type of treatise is often called the scholarly treatise. These books can go into such detail that they often span several volumes. There's no clear definition for what makes a treatise scholarly, though one clue you're dealing with that genre is if the name of the author of the first edition of the book is part of its title, such as Williston on Contracts. Scholarly treatises are useful for finding rule statements on narrow issues of law. They are organized according to topic, which helps locate the section that will be relevant. Like any good secondary authority, it will contain citations to primary authorities that back up that rule. However, you need to keep the jurisdictional scope of the title in mind. If it covers the law of all 50 states, it may not include citations to authorities in your jurisdiction. Even if you do not find citations to the law in your state, these are great resources to help you frame your issue and generate search terms. The American Law Reports, or ALRs, are a series of articles, in this case called annotations, that address a specific type of conflicts that can arise and compile the cases that have dealt with that issue. Often, an ALR annotation focuses on how a legal doctrine applies to specific factual circumstances. You can see how narrowly focused ALR annotations are by their titles, such as Liability for Injury to Martial Arts Participant. Because each ALR annotation is so narrowly focused, if you find one that is related to your dispute, you will likely find the best possible authorities. Of course, it's also possible that an annotation specifically related to you has not yet been written. ALR annotations do not focus on explaining the law, though there will be a brief contextual introduction. Rather, they list holdings in every related case across every jurisdiction and sort the cases according to fact patterns or outcomes. Law review articles are not necessarily written with the legal researcher in mind, but they can nonetheless be useful for substantive legal research in the right context. While review articles can serve many different functions, the most common function is to describe an area of law that has an inherent issue that has yet to be fully resolved by the courts or legislatures, and then proposes a way that lawmakers should deal with the issue. They often have a more historical focus than other secondary authorities, and might incorporate research from the social sciences to make a factual point. If you're researching an area of the law that you know to be controversial, searching through recent law review articles may be a good early step. If an article on point exists, you will likely have a very in-depth survey into your issue, but, like with ALRs, there may simply not be something on point discussing laws in your jurisdiction. There are multiple methods to find relevant sections of secondary sources, and successful research often involves a mix of these methods. When you're researching using a major database, you can perform keyword searches within a scope limited to a specific title. This can be a quick way to find relevant sections, but it is most effective when you already know what terms are used by the practitioners in this area of law. If you suspect that you would use an incorrect term, it might not be the best first approach. Most secondary sources will have a table of contents that is divided by broad topics, with increasingly specific topics nested inside them. If you don't have a good sense of how that area of the law works, browsing the table of contents headings can serve two functions. It will give you an idea of how that area of law is organized, and it will also lead you to the subject that you are researching. For example, you might not know the term contra proferentem, but if you know that you're looking for rules on how to interpret a contract, you would know to look at the section headings under the chapter on rules of interpretation. Indexes list all the topics covered by a title and point to where in that title that topic is covered. This is an alternative way to find the section you need based on terminology, while it may seem a bit more indirect than using a search. If you search for an alternative term that is not used in the discussion of the topic, the index is likely to contain a cross-reference that will direct you to the correct term, and then to the section that discusses that topic. Indexes also tend to let you choose among various subtopics. Finally, the most important part of using a secondary authority is using the citations to primary authorities. Any rule statement needs to be backed by a case, statute, or regulation that has the force of law behind it. You should refer to that law, confirm that it stands for the proposition that you intend to cite it for, and then use that authority in your argument.